Mr. Zhulkarnain Abdul Rahim.
Mr. Speaker, sir, I rise in support of this bill. I'm a disputes lawyer in a law firm with an insolvency practice. The proposed amendments in this bill will help save public resources and make better use of the official assignees' involvement in bankruptcy proceedings. I also welcome the Ministry's calibrated approach by proposing these amendments after the learning experiences drawn from the earlier initiatives introduced in 2016, which required institutional creditors to appoint public trustees in bankruptcy, or PTIBs. However, I have some clarifications and suggestions. My speech will cover three parts. First, on the recourse or redress against errant PTIBs. Second, learning lessons from jurisdictions abroad. Third, protection of members of the public from certain transactions with undischarged bankrupts. The first, I understand that to date, the administration of bankruptcy cases filed by institutional creditors have been smooth and that there has been no action taken against PTIBs by the court or the OA. However, whilst there are no actions taken, may I ask if there has been any complaints or investigations against PTIBs during this period? And if so, how many cases have there been since 2017? May I ask the Minister, what are the avenue or recourse for redress by aggrieved creditors or those who may have complaints against PTIBs? The role and oversight of PTIBs will be more important now because currently PTIBs handle almost 50% of the administration of bankruptcy cases. However, with this bill, they will likely cover almost 100% of those cases, except for cases involving public interest. I thank the Honourable Minister for clarifying the types of public interest cases and that the OA still retains the discretion on involvement. I hope that this will allay concerns of individual creditors or laypersons who may not have the means to hire PTIB from not proceeding with a petition for bankruptcy. Given the expanded appointment of PTIBs now for all bankruptcy cases, would this overlap with the work done by debt recovery firms, credit counseling firms in the market? Would more creditors or debtors now go directly through these firms instead of undergoing bankruptcy regime in courts? I appreciate that the Ministry has consulted stakeholders and appreciate that the Ministry will continue to consult along the way. In this regard, we can still learn from some of the lessons and experience from other jurisdictions abroad. My second part. In the United States, given the high volume of bankruptcy cases and increasing quantum of debt in total, the US General Accounting Office warned that there is a high risk of private trustee fraud if there is no rigorous review of trustee candidates, no proper conflict of interest declaration, no enhanced reporting requirements, and not sufficient funding for oversight by the DOJ. In Canada, their licensed insolvency trustee, LIT, must have the requisite knowledge, experience, and skills to be granted a license from the Office of the Superintendent of Bankruptcy, or the OSB. LITs are subject to ongoing oversight by the OSB and must adhere to federal standards of practice, including the Code of Ethics for Trustee. Hence, with the expanded regime proposed in this bill, would similar standards or codes for PTIBs be implemented or updated in Singapore? Besides overseeing and regulating PTIBs, what are the plans by MinLaw or the OA to ensure the standards and quality of our PTIBs in Singapore? For instance, would there be continuous training or mandatory courses for PTIBs? Separately, here, there is no solicitor-client privilege between a trustee and a debtor currently. However, in Canada, the Bankruptcy and Insolvency Act and the Canadian Association of Insolvency and Restructuring Professionals rules prohibit a trustee from disclosing confidential information to the public unless required by law or with the debtor's permission. If I may ask the Honourable Minister, would there be a similar rule for confidentiality here? What are the obligations owed by the PTIB and the debtor, perhaps with the overriding obligation or duty owed by PTIBs to the court and the OA? With regard to PTIB's remuneration, I agree with the additional means of determining such remuneration. For instance, there is a deemed consent for remuneration if no objection is received from creditors within a stipulated period of time. However, what are the safeguards to ensure that such notice is appropriately given, especially for individual or layperson creditors? I echo Honourable Member Murali Pillai's suggestion to include emails as mode of transmission for such notice. Separately, there can be more regulation or transparency in terms of remuneration. In Canada, LITs do not typically charge for their first consultation, and the remuneration is regulated by the federal government. The last part of my speech on protection of public members. The new section 412, subsection 1D, makes it an offence for an undischarged bankrupt to receive a deposit of at least $10,000 from any person if he or she does not disclose his or her bankruptcy status to that person. I thank the Minister for the useful illustration just now given in his speech. However, what is the rationale behind the quantum of $10,000? What if there is a series of transactions with multiple persons with an aggregate amounting to at least $10,000? If the undischarged bankrupt takes in several deposits from various persons totaling more than $10,000, then for the protection of the greater public, it would make sense for the entire series of transactions to be taken into consideration for the issue of non-disclosure, and not just based on the quantum of one single transaction alone. Next, on the new section 433, subsection 1, which enhances the amount of publicly searchable information about undischarged bankrupts. This is most welcomed, as it enhances the due diligence when transacting with persons who are undischarged bankrupts. I would like to humbly suggest including within the current database searchable information for persons who are not only undischarged bankrupts, but also those who are presently undergoing or facing bankruptcy proceedings. This will help with due diligence. Currently, to do so would require a court litigation search, and this would involve costs, and which may be prohibitive for some, and the process itself may be too tedious or unknown to laypersons. Further, if I may humbly suggest a one-stop searchable database, which would include pending bankruptcy application and details of an undischarged bankrupt's PTIB, so as to allow the public member to conduct further due diligence on not only that person, but the PTIB in question. In conclusion, Mr. Speaker, sir, today, at the opening of the legal year in the Supreme Court, the Chief Justice, Attorney General, and the President of Law Society addressed various issues impacting our legal landscape and profession, none more so important than the access to justice and upholding the rule of law in Singapore. Borrowing the words used by the President of our Law Society, Mr. Adrian Tan, this morning, and I may paraphrase a bit, justice is not the privilege of a few, but a promise made to everyone. This is our calling. For those of us in the legal profession, I want to thank MinLaw for pushing forward this bill. This bill will help us to achieve more efficient outcomes and effect justice, not just for creditors, not just for members of the public, but also for debtors and bankrupts alike. Notwithstanding my clarifications, I stand in support of this bill.